before a work can be copyrightable, there needs to be an element of human authorship. Since artificial intelligence cannot be qualified as a human, right, a natural person, any work that is produced by artificial intelligence may face that pitfall because it's not produced by human, and hence it doesn't fulfill the requirement under copyright law, and hence copyright would not be accorded to that particular work.
Welcome to another episode of the Legal Insight podcast by HHQ, where we help you make sense of the world of law, business, and tech. Today, we continue the conversation on AI and copyright. This time, we discuss the question of whether AI-generated work could be protected by copyright law with our technology practice group partners Ong Johnson and Lo Kai Yi.
Johnson and Kai, thanks for joining us in the studio. Can you start by explaining to us and our listeners, what is AI-generated work and how does copyright laws address AI-generated work in this current market?
Of course, there's a very wonderful question. So basically, AI-generated work, it essentially means work that's produced, that's generated by AI. So for example, I'm sure that most companies and most of us, we are using ChatGPT to produce certain kind of work. And a lot of different industry, they are also trying to leverage on AI in order for them to increase the efficiency and the effectiveness of their work. And then one particular importance that actually stood out compared to different industry is the creative industry. Basically, the creative industry, they are investing tons of money in the latest AI technology to produce music, songs, films, video games, and different kind of design. So right now, the main concern is that after those companies, after those studios and artists, after they have spent substantial amount of energy, resources, and money investing in AI, the main concern is whether the outcome of the AI, whether the AI-generated work, whether the finished work could be protected by copyright law. And this is a very big concern because the last thing that any company wants to achieve is after spending tons of money, they realize that the final work, the finished work could not be protected by copyright.
Pirates of the world rejoice, right?
Exactly.
Anyone can use
It's
your
actually
work
benefiting
now.
some people, right?
Yeah. Yeah. So, laws are drafted by, men and women way back when AI wasn't even a thing. Like AI was like, this little toy car, controlled by your remote, right? That is as far as AI goes. But, in today's landscape of AI, what are some of the challenges lawmakers are facing?
Yeah, you made a very good point there, Zach. You said that AI copyright law has been drafted long time ago, right? When the concept of AI may not even be so prevalent, or rather so commonly and widely understood as it is today. So naturally, copyright law, when they were drafted, at that point in time, the drafter themselves didn't even take into considerations that there could be copyrighted work, or rather there could be work that will be generated by non-human authors, in this case artificial intelligence. So naturally, the copyright law that we have today, there's a void in a sense that they all need, before a copyright, or rather before a work can be copyrightable, there needs to be an element of human authorship. So since artificial intelligence cannot be qualified as a human, right, a natural person, so any work that is produced by artificial intelligence may face that pitfall because it's not produced by human, and hence it doesn't fulfill the requirement under copyright law, and hence copyright would not be accorded to that particular work.
How about the human who gave the prompt to produce that kind of work? Does that not constitute, human produced work?
Yeah, so we, in our previous podcast, we spoke about what are the requirements for a work to be qualified or eligible for copyright protections, right? One of the conditions that we mentioned was effort. So when it comes to human giving prompt, there is an argument that may not be itself a very laborious work, or rather there may not be sufficient effort for whatever work that is created by the AI to be qualified as a work per se.
Maybe a follow-up question to that, Johnson, can you walk us through maybe some current case studies that are already happening that highlights the challenges in copyright laws in protecting AI generated?
Yes, definitely. So basically right now, there are a couple of particularly US. I mean, US, I think that they are considered the most advanced country when it comes to AI development. So basically right now, there are a couple of cases that's happening in US right now. So today, I think that we'll be happy to be sharing two of the more prominent cases. The first one is actually something very famous. So basically, a computer scientist was actually trying to copyright a fully AI-generated image. The title of the image is actually called A Recent Entrance to Paradise. The computer scientists make it very clear by saying that this image is fully generated by AI. And then the US court ruled that this piece of AI image is not eligible for protection. It's not eligible for copyright protection because it doesn't involve human authorship. Another very good example, and also a very famous example, is actually a comic book. The title of a comic book is called Zaya of the Dawn. So basically, the entire comic book, the image inside the comic book is fully AI generated. So there's a twist to this story. What happened is initially the artist, maybe we shouldn't call them the artists because the image was actually generated by AI. But the thing is, for the sake of discussion, we just call the creator the artist. Mm-hmm. So the artist was actually trying to register the copyright for the comic book, and then it was successful. The copyright office, not knowing that the image was generated by AI, actually granted the copyright protection. But later on, after discovering that the images were actually generated by AI, the copyright office actually reversed the decision by making very clear, stating that the image within the comic books which were generated by AI are not eligible for copyright protection because it does not involve humans. Right. So I think that these two cases make it very clear, especially in US, they make it very clear by saying that if any particular work that is generated fully by AI without human involvement, they are not eligible for copyright protection.
So maybe a question to Kai, perhaps, how does the situation in Malaysia compare to this case? In the US, it's so advanced. Is Malaysia catching up anywhere near where US is right now?
Yeah, so in Malaysia, the things are slightly different from in the US. Our Copyright Act is not drafted entirely word for word, mirroring what the law in US is. So in Malaysia, there are 3 conditions for work to qualify for protections. One of those conditions is that the author of the work must be a qualified person, and a qualified person is defined as an individual or body corporate in Malaysia. So because that definition in itself doesn't make express mention of AI, it is arguable that any work that is generated by AI would not fulfill the condition and hence would not be qualified for copyright protections. But at the same time, I mentioned that there are 3 conditions for a work generated in Malaysia to be able to qualify for copyright protection, right? The other 2 conditions are first, publication in Malaysia, and also number 3, if the work is made in Malaysia. So in the case of an AI-generated work, I think you can very much argue that so long as it's made in Malaysia, or so long as it is first published in Malaysia, they will fulfill the second or the third conditions and hence qualify for copyright protections. Now, of course, there is still some ambiguity, right? Because in Malaysia, our law, there is still a requirement for any work to be created. The copyright in and of itself should first vest in an author. The word author is expressly mentioned in the copyright law, and author is defined as a natural person. So in the case of an AI-generated work, again, since AI is not a natural person, so where does the copyright ownership first vested?
People generating AI-generated work or prompting for AI-generated work is not just creators or individual artists. It's also companies. They're investing a lot of money now into AI tools to generate work, to do tasks, to make things more efficient. So maybe you can give some advice, like how should companies actually navigate these copyright laws in place?
Of course, I think that from what we are seeing now, at least from the direction that's coming from UK and US, it's very clear that if AI, the final product of the AI is fully generated by AI alone, it's going to face huge challenge for it to be protected by copyright. But the thing is, on the flip side, if human or companies, they are actually leveraging AI as a tool in order for them to actually produce the work, we believe that this is able to actually eligible for copyright protections. So is there a very clear answer as to like what you mentioned just now? What is the amount of prompt, what is the amount of human involvement, and then what is the amount of AI involvement? That answer is yet to be clarified by the court. So basically, I think that it's very important for companies to actually work very closely with lawyers. They are familiar with this development in law, because the last thing, like what you mentioned, the last thing that a company wants is after spending a lot of money, then only receive a court judgment, only being declared stating that the work cannot be protected. That is the last thing that a company will want to achieve. And of course, as I mentioned, different jurisdictions is having different kind of guideline, also having different kind of regulations. So it also boils down to the laws and regulations of different countries as well. So in short, is to really work closely with lawyers that are familiar with this practice area.
The main industry that's affected by copyright laws is like the creative industry, or people generating creative work.
Correct.
Are there any other companies that you think could be affected by this?
Definitely. I think that a lot of times it's more than just a creative company. For example, let's just use the car companies, automotive. So for example, a lot of time, the design of the car itself, the design of the wheel, the design of the steering, everything is actually a form of copyright. Basically, if I'm the one who designed it, then naturally I am being the content creator, being the designer. I actually own the company, will actually own the copyright. But what if the company would actually just ask the AI to generate the latest design of a supercar? In that case, is the company able to actually get the sufficient protections towards the final outcome that is fully produced by AI? So basically, I think that not only creative industry, but different kind of industry that involve in design, be it automotive, be it, for example, producing food. For example, I can be a food manufacturer. So basically, if I get AI to design the food, so can the design of the food being protected? So not only creative industry, but basically we believe any industry that involve design, and especially they are leveraging on AI technology, should pay particular attention to this development.
So if I understand the conversation so far correctly, as long as, let's say, a company or a person prompts for a particular design or work, and subsequently he can prove that he has tinkered with the AI generated work enough, he can be afforded some form of protection.
My quick thought to that question is yes, but provided that really a lot of tinkering has been done, right? We are talking about generating a piece of design, for example, from scratch through the use of an AI. Then the author, or rather the person using the AI, actually do pretty much an overhaul, or rather change a substantial portion or substantial part of the design, right? Then I think it is arguable that it is no longer the same work.
Yeah.
The output, right? The end product itself is no longer the same as the initial output that was given by the AI. Then I think in that kind of scenario, yes, you may have a good chance, right, to argue that substantial labor and substantial effort has been put in to create an original work. Again, this is still subject to interpretations of the law by the court, and also by the decisions of the judges, right?
Yeah. So I think that just to add on, one of the very important tips is when a company is going to leverage on AI to produce the work, and also if the intention is to really receive the copyright protections, which I think that should be the case, they should really document the process. Basically, when I say document the process, they have a very clear documentation of the involvement of human authorship, and also how are they just leveraging AI as a tool itself. So basically, this can be tendered as a very crucial and substantial evidence in the event where this matter is being challenged in court.
Having said that, Kai, any final thoughts or recommendations to our listeners out there?
Yeah. So I really echo very much what Johnson has shared just now. Seeking guidance and legal advice from lawyers would be very, very crucial for any companies that are looking to leverage artificial intelligence in their day-to-day operations, especially in the creation of work that the company is then going to commercialize, right? How a team of lawyers can help is they can help you and help the company's internal legal, in-house legal, to craft tailor-made policy or tailor-made guideline on the usage of AI. so that employees, they know full well what are the do's and don'ts when it comes to the leveraging and the usage and adoption of AI and the incorporations of AI in their day-to-day task. So that way, company can steer clear of any unwanted dispute or any unwanted doubts, right, as to whether the work that is created by their employees would have sufficient IP protections or not.
Thanks, Kai. Thanks, Johnson.
Thank you.
Thank you.
That's fascinating, actually, this conversation, and it's still ongoing as we speak, right? That concludes our episode. Thank you for joining us for the Legal Insight by HHQ. If you found this content helpful, please show your support by rating, reviewing, and sharing it with your friends or business partners. Tune in next week for more thought-provoking discussions on the intersection of law and technology. Until then, stay tuned and stay informed.